Welcome to Win with the Law with your host, Gary Newland. In the Win with the Law podcast, your host, Gary Newland, partner at Newland and Newland LLP, invites guests who are experts in the personal injury law arena and other areas of law of interest to discuss topics relevant to the general public. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Now here's the host of Win with the Law, Gary Newland.
Welcome to Win with the Law. Learn how to navigate the legal landscape, end up on top with the help of legal community's most prominent lawyers. My name is Gary Newland, a trial lawyer with Newland and Newland LLP. We will discuss issues involving the law and strategies for success, so those listening can be empowered to achieve successful outcomes. Without further ado, I would like to introduce Erin Adamski. Erin is an attorney and partner at Newland and Newland LLP. She regularly resolves cases in excess of $1 million, focusing her practice on personal injury litigation, including wrongful death, truck and auto crashes, trip, slip and falls, poisonings, food poisonings, and other types of poisonings, and other areas where folks are personally injured. Welcome, Erin. And tell us, how long have you been a lawyer? Where did you go to school? Give us some background information.
Thank you, Gary. Yes, so I went to University of Illinois for my undergrad, and then University of Illinois at Chicago, formerly John Marshall Law School. During law school, I interned the entire time. I was always in personal injury, always knew that I wanted to represent injured individuals, pardon me. I looked more at medical malpractice in law school. It gave me a really intimate knowledge of injuries and body parts, which is something attorneys don't graduate law school knowing. So that was very helpful going into personal injury law. Once I graduated law school, I was always in personal injury law. I worked for one firm prior to coming to you and then have been with Newland and Newland since. I've been a practicing attorney for about 10 years. It's hard to keep track. I think it's been about 10 years. And really, really loving always in personal injury, but not specifically and exclusively personal injury. We do also practice in other fields of litigation. I also explore and dabble in defamation, both the plaintiff side and the defense side. I also am involved more extensively than I anticipated in probate law. A lot of injured individuals are minors or unfortunately pass away from their injury. So there's a lot of probate overlap in personal injury law. So I've been fortunate enough to be able to represent my clients when they need to be involved in that part of the court system as well.
It's helpful, Erin. And, when we discussed what we were going to do today, we decided to focus on a car accident case and the issues that come up in a car accident case. And part of the stuff that comes up is, what should you do? What is discovery? What happens with discovery? And I believe we decided this is probably going to be more than one podcast. So we're going to start with, we'll call it podcast number 1. Erin, if you could advise the listeners, what should they do upon being in a car crash?
Sure. So it's really overwhelming, and there's a lot that happens, of course, when you realize that you've been in a collision and something hurts. A lot of people, it first happens and they don't necessarily know what to do. They're at the scene, and you're at the scene for a while. So the first steps that you can take to put yourself in the best position possible actually happen while you're at that scene. You want to take as many pictures as possible. Of course, there's going to be damage to your vehicle. So if you can get as many pictures as you can of the damage to your vehicle, that's going to really help you, as well as the damage to the other vehicle or vehicles involved in the collision. Also, if you were caused to hit other pieces of property, perhaps a light post or a sign, you want to get pictures of whatever other property you were caused to hit. That's going to be helpful to your case later. You want to make sure that you can just take as many photos as possible as well as potentially to your body. If your arm or your head were caused to hit something, that's going to help you later in your case as well. So just document as many things as you can while you're still at the scene.
Now, what should a person do when confronted with communicating with the other parties in the accident or witnesses or even the police?
Yeah, so it's very common when somebody hits you or causes their car to collide with yours. It's very common that they're going to get out and they're going to come ask that infamous question, "Are you okay?" So, if you can avoid saying, "Yes, I'm okay," that's going to help you later in your case because anything that you say we've all heard can and use against you in a court of law, right? So if you can avoid saying yes, I'm okay, we're not saying you should be rude. Being polite is always best in life, right? And that's best in your case as well. But if you can be polite without saying yes, I'm fine, because you're not fine. You're hurting. You're just probably have adrenaline coursing through your body. So you might not really recognize what hurts, what doesn't. So you can respectfully say that you appreciate them checking on you without saying you're okay. That's probably going to be best for you later in your case. You also want to make sure if the person checking on you isn't the person that collided with you want to get that person's information. A lot of times there will be bystanders around that will come help you. Oh my God, are you okay? I called the police. They're coming. Just wait. This happens a lot of times, and police will very frequently get their names and phone numbers if they can, but that's not always possible. Sometimes those people need to get to work or something like that. So if you're able to get their name and contact information, that will be very beneficial as well. They may have seen something that will help you later also, not just for proving liability, which will be our job to establish as the plaintiff, but just because they might have seen something and what you don't know, you can't use. So if you're able to get their contact information, that's going to be very beneficial.
Aaron, do you think it might help if the person has an opportunity, right? Not everyone has the opportunity after a car accident because sometimes they need to be extracted from the car or whatever else. But if they are out and about, if they could take a picture of any skid marks that may exist on the roadway as well.
Oh, of course. Of course. Obviously, if you hurt your leg, you don't want to be out walking on your leg, right? But if you feel capable, anything on the scene that you can document because that evidence isn't going to be in existence later. So we don't expect the everyday person to know what evidence is, but if you see something and you know it came from your car, take a picture of it. If it doesn't end up helping you, then it doesn't hurt you to have had it, pardon me. But why not take a picture of it and let us decide if it's something relevant to your case or not? So go ahead and capture anything that you can possibly capture. Additionally, because once it's towed, if that's the case, you may lose the opportunity. So capture as much as you can possibly capture with your phone. A lot of people take videos also. If you're like me and not sure how to do that, big photo at one time, that panoramic, I think it's called, you can take a video showing how long the skid mark goes on the street. That's very helpful too. So again, it's about collecting as much as you possibly can right then and there, always under the caveat of, though, if you're able. Don't ever put your body into potential to exacerbate or aggravate the injury that you know you're feeling. This is all, as you said, Gary, if you're able. A lot of the times you're going to be told to remain in your car and always follow what the paramedic or police officers tell you to do, of course.
So, Aaron, is it inevitable that when the accident is not your fault, or even if it is your fault, sometimes you're going to get a call from an insurance company asking for a recorded statement? What should a person do when that takes place?
Inevitable is a very good word. So, very, very likely, if not inevitable, you're going to be contacted by both your insurance as well as the other party's insurance. So, when you're contacted by the other party's insurance, you just want to say, I'm sorry, but I either already have an attorney or I'm retaining an attorney. Once you've advised them that you have counsel or you're retaining counsel, they have to back off Will they keep trying? Potentially, but you just keep saying you have counsel, you're retaining counsel. You never want to give a recorded statement. Again, this can be used against you later. It's not because you're not intelligent enough, it's not because you might mess up. It's just again because you have so much going on in your life right then. You're in pain, you're trying to make sense of everything. It's just best to wait and not say anything that might hurt you later, you might regret later. Your own
Aaron,
insurance company is the same story too. Oh, I'm sorry. Your own insurance company you don't want to speak to either, excepting if it's about your property damage. Your vehicle will not get fixed usually unless you give them very limited information. So you can speak to your own insurance because there's a contractual obligation there between you and your own insurance. But just make sure that you limit that to property damage details and not anything about your injury.
so, so basically, under no circumstances give a recorded statement. Is that a good rule to live by?
And they will tell you that it's going to be recorded. So just never talk to them. And if it makes you feel better, just don't answer. If you're just nervous about it, just don't answer. Make sure when it's your insurance though, you're like I said, there might be a contractual obligation there. So make sure that you at least answer any questions they have with regard to your property, your vehicle that was towed. You don't want any issue there. They might be trying to get it fixed for you, get it back to you. So that's separate from the other party. When it's the other party, just never give a recorded statement. Just err on the side of caution, just don't give it.
So, Aaron, and one of the reasons for that is even if you're completely honest, at the time they call you, you may not have a manifestation of pain in your knee. And they're going to ask you, where do you have pain? And then when you get off the phone or the next morning, you could have pain in your knee, and that could be your worst injury. Sometimes it takes longer to manifest, but they'll have a recording of you shortly following the accident. They'll ask you if anything else is bothering you, and you'll say no, and you won't mention the knee, and then therefore becomes more difficult to get compensation. Is that fair?
Yes, absolutely fair. And there are so many types of injuries that present as pain to one part of the body that are actually an injury to a different part. Very commonly, a shoulder injury initially presents as pain to a neck. A hip injury presents as pain to the groin. I mean, there's so many issues or I'm sorry, so many injuries that initially present with pain to a different area. So you're hurting yourself potentially by saying my shoulder hurts or my hip hurts or my groin hurts or my neck hurts, and you're not, although you're being honest, you're being completely truthful, you're potentially, to quote you, shooting yourself in the leg by saying this is what hurts when actually here's what your injury is going to ultimately be. So it's just less is more. Less is always more in the law. Just wait. Less is more. Don't talk.
So, Aaron, what about social media? Should that ever be utilized by an injured person?
So that's not a less is more, that's a none is more. Just don't go on
Mhm.
social media at all when you've been injured. Just don't do it. The defense is going to find everything that you say about the injury, period, always. It's in our first letter to our clients. We tell them over and over, they will find a picture of you dancing if you say you broke your foot. They will find a picture of you lifting your son if you say you broke your elbow. I mean, they will find everything that you do on social media. So you just need to be very careful. But again, if you're being honest and it hurt, then you can't do it anyway. So it's just all about being truthful and honest. So don't go on social media and say that this, and this happened. Just leave it alone. Just leave it alone.
You don't want to go on social media because, let's say you're at a wedding and there's a picture of you dancing with your spouse at the wedding. And although it hurt, and afterwards you paid the price, and maybe you weren't able to stand up the next day, or who knows. But the reality is, once they get the picture of you dancing at the wedding, you've just lost credibility.
So it
Because it
becomes
doesn't
a
show the pain you went through, does it, Aaron?
Right. So it becomes a battle we need to fight because you're trying to enjoy this event that you were already going to. You don't want the pictures that you're going to have for the rest of your life showing tears coming down your face because it hurt that bad. So you muster through it. but then you suffered afterwards. Well, now we have to explain that. So just do yourself a favor and stay off social media. We aren't coming up with these rules like parents. We're trying to help you. So just stay off social media to the benefit of your own self and your own case. Just, I know it's hard. Find another platform for a little while. Just don't do it.
So with respect to things, what do you expect a person to come to the office with if they're going to come in for a personal appointment after a car crash?
So the first thing is the sooner you can get to us, the better. Because a lot of the times, 9 times out of 10, there's going to have been a 911 call, and that 911 call is very helpful. But that footage is only preserved for a certain period of time, or that whether it's video footage, whether it's verbal, whatever, it's only going to be available, that recording, that statement, that phone call, whatever it was, for a certain period of time. So the sooner you can get to an attorney, the more helpful it is. It doesn't make you look more or less litigious. It just helps you to get to us the sooner that you can, pardon me. Also, there may have been businesses in the area that captured the event. They're only going to have that footage available for a certain period of time as well because they weren't involved necessarily. They may have just been a bystander that captured it. So, kind of a precursor to your question, Gary, but the sooner you can get to us, the better. Once you come into us, then the more information, the better. Again, we need to know everything that happened. We need all of the photos you have, all of the witnesses' names that you might have, even if you don't have their phone numbers. We need everything that you know. We also need to know what injuries you believe you sustained. We don't need the medical terminology if you don't have it, but we need every injury you believe you sustained. And this is critical, the history of that body part in your body. If you've ever injured that body part before prior to this collision, if you have, this is separate from an injury to that body part, if you have a pre existing condition, if you have, for some reason, extremely bad arthritis in that knee, that's not an injury, but that's a separate condition in that knee. If you have lupus that frequently flares up in that particular joint, we need to know whatever the history is in that knee because we can't anticipate the battles that we're going to fight and what we need to know if we aren't told. So it's not just knowing everything about the collision and everything you know about the collision, but we need to know everything about your body as it relates to that body part, whatever part you've injured, because it's your body, right? So if you don't tell us, we're not going to know, but we're going to find out later. And the defense is going to find out later. So the sooner you tell us, the more ahead of it we can get from the start.
Well, you've mentioned that it's helpful if they take pictures, bruising or whatever else would be helpful. What about deleting pictures? What should you tell a client about deleting pictures?
So it's really important to never delete any evidence you have, any pictures that you've taken, or if you did post on social media before you came to us. It's really important to never remove or destroy, is what the law calls it. It's a little harsher word. Never destroy any evidence. There is an electronic trail always, and it will always show that you did destroy that evidence. So you need to always preserve any evidence that you've ever had or any statements that you've ever made. We will figure out what to do with it, even if it showed, for example, that your arm looked fine. 2 days later, the bruise developed. Okay, we will work with whatever we need to work with. We can't work with a lie. So you just need to always be honest with us and show us what you have, what you don't have, or maybe you accidentally deleted it. Okay, explain to us that your son was playing with your phone and he accidentally deleted the photos. Okay, we'll retrieve them. We'll work with what we have to do. But again, if we're not made aware, we can't do anything about it.
Interesting. So essentially, the destruction of any evidence, the court can hold against the party who's injured if they destroyed it, correct?
Correct. Can
Okay.
and will.
Now, so after the person comes in and are these cases normally, do lawyers charge hourly? Are they done on contingency fee? How do lawyers normally charge for a personal injury case?
Sure. So personal injury is contingency based. And what that means is we only recover if you recover. One of the most common questions in personal injury too is it is a lump sum recovery. The insurance company, and I say the insurance company because I also want to point out when you are bringing a case against somebody in a motor vehicle collision, you are not suing that person. That's going to be the name on the other side of the complaint, but you are actually seeking recovery from their insurance company. That's why we all have insurance. It's Illinois law. You're seeking recovery from that insurance company. Federal law requires such too. We're not going to get into that. But when you recover from their insurance policy, the insurance policy is not going to write a check for your bills, for your attorney's fees, for your litigation costs, for your pain and suffering. It's going to be one lump sum recovery from which we, as your attorneys, pay out to your medical bills and pay out to you for your recovery, and then pay ourselves for any litigation costs that we've incurred and our fees. So we are not paid until the very end. We are working from now until the end based upon what you're telling us. Again, why it's really important you're honest with us. But also, you're not paying us along the way. So while you're injured and incurring medical bills and very likely unable to
You
work,
know, in,
you're
yeah.
not paying us.
Right. So the lawyers advance all the funds that are needed to pursue the case. And what sort of funds are those? Are there doctors' records, expert fees? What else is there out there?
Exactly. We are advancing all of the costs, and the costs increase as the case progresses. So in the beginning, we're paying for record, well, potentially actually, we could even be paying for a black box download. What that is a retrieval from your car of exactly the electronic steps. So your car will tell us exactly what you did right before the collision. This is not available in all cars. It's not available in some older cars, but it will tell us exactly what happened right before the collision. We make the determination based on the facts of the situation whether or not we need to do that. But that would be a really early on fee. Then we're going to be paying to collect bills and records from everywhere that you treat. So the more places you treat, the more bills and records costs there's going to be. Beyond that, when we proceed to oral discovery, so after written discovery, after we're answering questions, which is written, answering questions based on what happened on behalf of our client and with you, then we're proceeding to oral discovery. We're taking depositions. So we're paying court reporters, we're paying potential independent witnesses for their time, we're paying for subpoenas. Then we're paying doctors. We have to pay them for their time as well as the court reporters. Then we may need to pay experts. We may need to pay liability experts or damages experts, meaning we may need to pay somebody like an accident reconstructionist to explain to the jury, because we're always preparing for trial from the first day you walk in. We may need to pay somebody to explain to the jury why the liability here is on the other party. It might not be as clear as it may seem to you. We might need to explain that via an accident reconstructionist. We might also need to pay doctors, not only your treating physicians, but potentially medical experts to causally connect all of the injuries. It's not always just straightforward. Sometimes there might be a path of injuries. It began with this injury that led to this injury that led to this injury. Or, as I mentioned earlier, you had a prior injury or a pre-existing condition which led you to be more injured than perhaps any other person would have been. So we need an expert to come in to explain that to a jury. These costs add up quickly. We advance all of that for you because, again, you're the injured party. You're not going to be suffering additional financial costs while you're recovering.
So costs can be related to the issue of how difficult it is to prove liability upon the other driver. For instance, in a clear rear end collision, generally you're not going to need to pay for a download of a black box. Is that fair?
Correct. As far as liability goes, the more clear cut it is, the lower the costs are going to be.
Right. And, some experts are needed sometimes because somebody can't return back to their job as a pipe fitter or whatever that job may be. And we would need an expert to testify as to that fact. Sometimes it can be done by a physician. Sometimes it needs to be a vocational expert or economics expert. But generally, the more the costs are, the more the recovery. Is that synonymous generally as well?
Yes, they're usually directly related. Unfortunately, the more injured you are, obviously the higher recovery you're seeking, and the higher recovery you're seeking, the higher our burden of proof is. And the higher our burden of proof is, the more experts we're going to need to prove that. We are experts in the field of law, not in the field of the economy or medicine or injuries or economics. So we need those people to come in their field of expertise and not only explain it to a jury, but explain it to a jury from their qualified position. And you deserve that because you deserve to be put in a position you would have been but for the collision. And that's how the law looks at it. Where would you be today but for the collision? So if that hadn't happened, where would you be? Well, that's what this economics expert and vocational expert is going to come in and say. They would have been making this much money. They would have been in this position at their career. They wouldn't have lost this much money in the past, et cetera, et cetera. So we bring in these people because we're trying to make you whole again.
So, and is it fair that a lawyer, like you said, isn't an expert in economics, but he can argue or she can argue the expert's opinion, and that's how we get compensation for clients. Is that fair?
Absolutely. That's what we're doing. We're taking all of these experts' opinions in their fields and then we're arguing it. That's the part we do is the argument. We're taking their opinions and then arguing. And
Yeah.
when it's simpler,
And
when it's just lost wages in the past, we can argue that without an expert. That's which goes to your point, Gary. The more complicated it is, the need for an expert comes into play. We don't always need one. It's not guaranteed to be a necessity in
right.
your case.
Now, sometimes we have a situation where someone had a previous injury to a specific body part, and it's our understanding that that body part was made worse in the crash. At that point, is it necessary to have a doctor prepare an opinion to support that there was an aggravation of a pre-existing condition?
Almost always. So if your treating physician was clear enough that you were performing the activities of daily life prior to the collision, so post your original injury, but prior to the collision that caused your new injury, the aggravation of your prior injury. If your treater was clear enough in your treatment records, we may be able to use your treater as our expert. If they were not, which is very common because treaters do not like to cross over into expert witnesses. And if that's the case, then we will bring in an expert to opine, as I just stated, that they had an injury, they treated for it, they resumed the requirements of their career, performing the requirements of their career, and they resumed performing activities of daily life up until this collision. The collision occurred. Now they have either a temporary or a permanent aggravation of their prior injury. And therefore, that can be traced causally to this collision that they just experienced, which is what we're representing them for. And all of that holds true to a pre existing condition as well, that they were treating for a pre existing condition. The treatment had put them at an asymptomatic position or put their symptoms under control to the point that they were performing the requirements of their career or performing activities of daily living until the collision occurred. Now their pre-existing condition has been aggravated to the point that they can no longer perform these activities, etc. They're slightly different, but they operate in the same way to the extent that the collision aggravated something that was previously controlled either by a surgery or by via treatment to symptoms. So in both cases, a treater can um, opine to that. When they won't, we will need to pay an expert.
So sometimes they won't because they don't want to get involved in legal medical, or sometimes they won't because they're too busy. Is that fair?
Yes, sometimes they won't because the hospitals that they work for won't let them. There's a variety of reasons.
Yeah. So after we as lawyers, we collect all the medical about the person. At about that time, in the case, we end up getting, if the case is in court, what's called discovery served upon us. Is that correct?
Yes, yes. So discovery has two well, I guess 3 main phases. So first is written discovery, second is oral discovery on the parties, and then oral discovery on experts. The written discovery on the parties is the first part and the biggest participation by our clients. They will next give a deposition, that's oral discovery. But the written discovery that we're discussing now is the first form of discovery, and it's in the form of interrogatories and requests for production. Interrogatories are just questions. It's just a fancy word for questions. Our client is asked a bunch of questions, mainly boiling down to what happened in the incident, what were your injuries, what's the treatment for your injuries, and how did it affect your life? So, how did it affect your life is going to encompass how did it affect your life because you'd never injured that before? Did it affect your life because you re-injured something? Did it affect your life because you already had a condition in that area? Because I promise you, they will find out all of this information if you don't tell them. Requests for production are requests for materials, requests for documents. If you missed work, how much work did you miss? Provide us that off work note where the physician said, I am treating this client for injuries subsequent to a collision. They cannot go back to work. If you're claiming lost wages, show us your tax returns if you're claiming enough lost wages, or potentially your supervisor can fill out an off work note. It just depends on how much time off work you missed. But it's the point is proving your case. We're the plaintiff and we need to prove our case. At the end of the day, we're seeking money. So if we want somebody to give us money, we have to show why. We have to prove why. That's not to say the defense isn't doing the same thing, though. I will have propounded on the defendant as well. I am seeking not what their injuries are. I hope they're okay, but that's not what I'm seeking. I'm seeking, why did this happen? What did you do or what did you fail to do? Were you not trained correctly? Were you not operating the vehicle correctly? Did you see my plaintiff get injured? What knowledge do you have of my client's injury? What documents do you have to establish that you were operating the vehicle properly, or that you performed inspections you were supposed to perform before you operated that vehicle, etc.? So both parties are answering these questions and producing materials so that the attorneys can discover, hence why it's called discovery, discover why this happened and how the plaintiff was permitted to be in a situation that got them injured.
Gotcha. So I think that's a great intro on what goes on with an injury case. I think for part 2, though, we should get more in depth on discovery. What do you say, Erin?
Absolutely. It's the most commonly and most questioned part of a personal injury case. I can't tell you how many questions I answer about these questions that my clients need to answer. So I would love to give them just a flat video that they can come back to.
Okay. So we'll save that for next time. And for now, I'd like to say we're signing off. And another great episode. Erin, thank you for your expertise and your experience and the way you conveyed it in such an easy to understand way. Appreciate it.
Oh, I hope so. I hope so. And thank you for having me.
You've
you.
been tuning into Win with the Law with your host, Gary Newland. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.